You know, when we talk about high-stakes litigation, everyone focuses on the courtroom drama.
Right.
But there's this huge logistical question that sits in the background of every multi-million-dollar case. Where does the money actually go while the lawyers are fighting?
It doesn't just sit in the safe in the judge's chambers, that's for sure.
Exactly. So today, we're looking at General Order 1604 from the Central District of California, and it reads like a procedural manual, but it's really the blueprint for a surprisingly sophisticated financial machine.
It really is. We are deep diving into the registry funds. And our mission here is to explain how the court evolved from, well, a decentralized mess into what is effectively a centralized investment powerhouse called C.R.I.S.
Let's start with that evolution, because looking at the history here, the old way, the pre-C.R.I.S. era, it seems kind of fraught with liability. I mean, you had court clerks effectively acting as local bankers.
But it was a nightmare.
Yeah.
A total nightmare. You had clerks managing individual accounts at all these different local commercial banks.
Yeah.
Imagine trying to track the solvency of 10 different banks while managing thousands of CDs. It wasn't just inefficient, it was
risky.
Incredibly risky.
So the shift to C.R.I.S., the Court Registry Investment System, that wasn't just an IT upgrade. It was a fundamental shift in asset class.
Right. They moved to a pooled investment model. So instead of your specific lawsuit money sitting in a silo, it's combined with funds from all across the federal judiciary.
And that scale is what allows the court to purchase government account series, or GAS securities.
Precisely. And for anyone who doesn't speak Treasury, GAS securities are key here. They're non-marketable securities issued directly by the Treasury.
You get the safety of the U.S. government.
Exactly. You get the liquidity of a savings account, but with the full backing of U.S. debt. It allows even small deposits from minor cases to earn market interest rates they couldn't possibly get on their own.
Okay, but the general order makes it clear that not all money is treated the same. The system segments capital into three very distinct buckets based on the case type.
Correct. The first bucket is the default, the liquidity fund. This is for your standard bonds or judgments. It's designed for speed. The fee is minimal. We're talking about 10 basis points.
Then you have the minors fund. This one is really interesting from a yield curve perspective. I mean, since this is money held for a child until they turn 18, the court knows that capital isn't moving for years.
Exactly. And because that time horizon is fixed and long-term, the system can buy higher-yielding securities. It's just a smarter allocation of capital.
But the third bucket, this one seems like the biggest value add for lawyers, the disputed ownership fund, or DOS.
Ah, yes, for interpleader cases.
Right, where you have a pot of money and multiple people fighting over who actually owns it.
This is the game changer. In those cases, tax liability is a disaster. Nobody knows who owes what to the IRS until the whole case ends. So the C.R.I.S. system steps in as the tax administrator.
Wait, they handle the withholding and all the reporting.
They do. Now, the fee bumps up to 20 basis points. But for that price, the court effectively removes that massive tax compliance headache for all the litigants.
That is absolutely worth 20 basis points. So let's get to the rules of engagement. I was struck by how strict they are about deposits. You can't just, wire money to the court.
No, not at all. You need a motion for leave to deposit, citing Rule 67. But the critical piece, the operational bottleneck, is the court order itself.
What do you mean?
If you send funds without the signed order, physically accompanying the transaction data, clerk is legally paralyzed.
Because without the order, they have custody of the asset, but no legal authority to actually classify it.
Exactly right. It goes back to that fiduciary responsibility. They need to know which bucket it belongs to immediately.
And there's one detail in the fee structure I think is crucial. The court creates a firewall around the principal amount.
That's right. Fees are deducted only from interest earnings.
So even if the case drags on for years and interest rates are low,
they do not touch your original deposit. The principal is sacrosanct.
So the case ends, you win, and you want to cash out. The disbursement order seems to be where a lot of law firms trip up.
It happens all the time. You can't just draft an order saying pay the plaintiff. The clerk's office is not your accountant.
So the order itself has to be hyper-specific.
It must explicitly calculate the split between the principal and the accrued interest. If you don't do the math in the order, the clerk cannot and will not cut the check.
Because the tax implications on that interest are different.
And that forces the lawyers to finalize tax liability before the money ever leaves the federal system. It's a brilliant mechanism, really.
So the whole system balances maximum safety, that Treasury backing, with the immense complexity of federal tax law.
It really turns the clerk of court into a high-level fiduciary, protecting the funds from both market risk and legal ambiguity.
Which brings us to the future. The source material hints at a big push for IT modernization.
Right. 2026 is the target. Cybersecurity upgrades, more digital remote access.
So it leaves me with this thought. This entire system is built on the stability of U.S. Treasury debt. But as asset classes evolve and we see courts digitizing everything, how long until a registry is forced to accept something like cryptocurrency as a valid bond deposit?
And how on earth would they bucket that for safety?
That is a headache I don't think the clerk is ready for yet.
I don't think so either.
Thanks for listening to this deep dive.